What's up, everybody? We have an interesting video today. Some unusual things happening in this Take Care of Maya case, where we've had the entire plaintiff's case in chief, we had the entire defense's case in chief, we heard some rebuttal from the plaintiff, but a major issue was opened up when the defense elicited testimony from an expert that this hospital got the AOK from government agencies at the time Maya was there. And it turns out that may not be true. So we've done all this digging to provide documentation the defense never turned over to plaintiff because it was not necessarily relevant to their case until the door was opened. And now documents have been revealed, experts have been deposed, corporate reps of the hospital have been deposed, and we are back this morning. This happened where arguments were made in front of Judge Carroll to see if any of these documents could be presented to the jury, could be sent back and entered into evidence for them to use during their deliberation, and if there could be any more testimony around just what happened with this immediate jeopardy finding. Did it have anything to do with anything else at the hospital besides the Heart Institute, which was widely reported, in which defense counsel argued that was the main reason for the IJ, nothing else to see here, Judge? Well, it seems like there may be more to see. And a lot of the information that came out in today's, I guess we'll call it a little mini hearing that they had that we're going to watch together. And then we'll catch a couple snippets from the expert from the plaintiff side to explain what this stuff means and why it should affect the way the jury looks at this case. So if you've been following along this trial, hit that like button and subscribe to our page for more on Maya and other trials that we are covering. So we start the day with Howard Hunter, the main lawyer for Johns Hopkins, talking to the judge, and the judge has some questions for Mr. Hunter.
Can I ask a question though? Yes. So you filed Ms. Green's affidavit and you filed a motion for clarification, and in none of those did you.
Ms. Green is the corporate rep or representative for Johns Hopkins that they deposed, I think it was Friday or this weekend, regarding all these issues.
You filed Ms. Green's affidavit and you filed a motion for clarification, and in none of those did you attach the immediate jeopardy finding. So what brought us here? Why did we omit the actual immediate jeopardy finding?
Oops. The judge ordered that everything be turned over. And if it was close, turn it over. If you're not sure, turn it over. If it's a maybe, turn it over, especially the IJ finding. And guess what? They did actually turn it over to the plaintiff, but they did not attach it for the court to see in their motion. They did not attach it to the affidavit of the person that was deposed this weekend. Why not?
From your affidavit and from the motion.
Well, the point of the affidavit, well, first of all, the immediate jeopardy finding was in a letter dated 1/31/19, and that has been provided.
But it was not sent to the court as part of the affidavit. It wasn't part of your motion for clarification.
It was not.
I mean, you attached a whole bunch of other things saying how wonderful everything is. But you didn't attach that.
Yes, sir, because the
That's all these things saying how wonderful everything was, but not that.
point of the filing was that the immediate jeopardy finding was immaterial and did not relate to the period of time that Maya was in the hospital.
So when I said to turn it over, you didn't immediately turn it over to the plaintiffs. You didn't even attach it and send it to the court. I mean, what am I missing here?
I think you're missing, Judge, what we're trying to get across in terms of what brings us here and what the real point of Your Honor's order was and what the real point of the testimony at issue here is.
So when I say to turn over the immediate jeopardy finding, you're going to interpret that not to turn over the immediate jeopardy finding?
No.
It's great when the defense can tell the judge what the judge's main point was when the judge said something, as opposed to the judge saying what the judge's main point is. The defense is like, the main point of your order, Judge, was, is this stuff relevant? The judge is like, no, when I said turn over the IJ finding, I meant turn over the IJ finding. And I knew that there were going to be arguments like this, which is why I said I'm going to be liberal and broad with what I allow. And what do you know?
Listen, Your Honor, we turned over the immediate jeopardy finding. By Friday morning, I have a
And
list.
they did turn it over to the defense. That's what's funny. I don't know why he didn't just start with that, but they didn't add it to the filing so the court could see it. That was the problem.
Here of about 30 or 40 different documents that we had turned over to the plaintiff in less than 48 hours after this all occurred. I've also got, since then, a list of about 170 others. We've provided nearly 1,500 pages of documents that include the immediate jeopardy finding. Counsel interrogated Ms. Green in her deposition regarding the immediate jeopardy finding. And the immediate.
Oh, now it's okay to use interrogated. right? It was not okay before the defense had a problem with that word. So we know they have some fire behind that definition. What's also interesting is he's like, we provided these documents within 48 hours and then 1,500 more in the next couple of days. All that tells me is you had all these documents that you refused to turn over. And the reason that they weren't turned over is because you wouldn't turn them over, not because they were hard to get. So that argument kind of flies out the window. Really interesting here to see the judge and the defense lawyer argue back and forth, especially when it felt like I thought the defense lawyer did turn over the documents, but he still was being prickly kind of with the judge. So it was an interesting conversation.
Immediate jeopardy finding, as she explained, was based on a site visit that the CMS did in January of 2019. If you read the report of that, which she testified about, you will find that all of the information that they gathered and all of the conditions that they addressed were set forth in that letter and related to that time frame. There was
When I went to look to actually read the immediate jeopardy finding, you didn't attach it. So how am I supposed to read it if you didn't attach it?
It's a problem.
Judge, my apologies for not attaching it, but again, the point of the affidavit and the point of our filing was to attempt to clarify the basis on which there was any suggestion that the immediate jeopardy finding was relevant to the hospitalization here at issue. What I was trying to get across to Your Honor, obviously unsuccessfully, is the fact that the premise of Dr. Corcoran's testimony is based on two things. One is that the immediate jeopardy survey took place in September of 2018 and was a quote look back unquote. First of all, there was no survey in September 2018, and secondly, the surveys don't look back; they look forward, and that's the second point of
the plaintiff's lawyer later asks or argues surveys looking forward and not back is totally makes no sense. That's illogical. You can't do a survey on things that have happened looking forward. You do a survey from what's happened in the past, right?
final. It was to establish the fact that at the time of Maya Kowalski's hospitalization,
I should say a survey like this. If you're doing a survey on what you want to happen in the future, you can do that. But when you're looking back at problems, surveys usually in the past. I think that logically makes more sense. But you can correct me if I'm wrong in the chat. I'm sure you will. You're not shy.
what Dr. Anderson or Mr. Anderson testified to, witness Anderson testified to, was that we were in good standing with JHACH and CMS. The point of the filing was that we documented that that was in fact the case, that certificates had been issued in 2015 and in August of 2018, indicating that we had been reaccredited and that accreditation, barring any other activity and barring any other violation, was good for 3 years. The period of time that was covered by Mr. Anderson's testimony, Ms. Kowalski's hospitalization, was in the fall of 2016. During that period of time, we had been accredited by the Joint Commission, and we've got copies of the certificates we provided. They're attached to the motion. The point is that the entire premise of this, that the immediate jeopardy finding was somehow related to the status of the hospital at the time of Maya Kowalski's hospitalization, is simply not true. There was not, the immediate jeopardy did not relate to any of that. The immediate jeopardy did not base its findings on anything that took place during Maya Kowalski's hospitalization, or that was even reviewed at that time. The point we were trying to make, simply put, is that Mr. Anderson's testimony, however brief and however summary, was simply correct to the extent that we were in fact accredited at that time, and that there was nothing untruthful or misleading presented otherwise to this jury. That was.
So Mr. Anderson is the expert that opened the door with the defense based on the defense questions, basically said everything was A-okay. And he's saying, technically, Judge, that was true at the time. Maya was there. But wait, because later the defense agrees to strike Mr. Anderson's testimony in an attempt to not allow the plaintiff to even bring up all of the stuff they want to bring up in rebuttal. And the judge is like, wait, a second ago, you just told me everything was legally and factually correct that he said. So why would you agree to strike his testimony?
The point we were trying to make.
Was there a culture? Did any governmental agency or the Joint Commission talk about a systemic failure of the culture at the hospital?
There was a discussion of that finding. There was a discussion of failings of plans that took place in January of 2019 that did not relate to anything that was occurring in the fall of 2016, 2.5 years earlier.
How do you say that? I mean, am I just to take your word for it? I mean, how do I know that when the plaintiffs just told me they got evidence of systemic problems, which apparently Ms. Green talked about in her deposition?
Your Honor, with respect, Ms. Green talked about in her deposition findings that were made at the IJ in January of 2019. If you look at the report that resulted in the IJ, it's a report from CMS that has been provided that actually indicates what the basis of the IJ was. And it talks about interviews and it talks about evidence that was gathered in January of 2019 during a site visit between January 7th and January 11th of that year. And then it relates some of those failings to its interpretation of policies that were adopted in September of 2018. None of that reaches back the preceding 2 years to when Maya Kowalski was a patient. The whole point of this is the whole premise of Dr. Corcoran's assumptions, and it was an assumption. He looked at that report. He saw the date of September 20th, 2018, and he assumed from that there was a Joint Commission survey at that time that resulted in an IJ. That's been proven to be incorrect. And also it's been proven that that was not a look back situation. So the whole premise of this, the whole point of this is not what was going on at the time of the IJ and the findings that were made regarding the IJ in January of 2019. The point of this case and the things we're trying to litigate here took place in the fall of 2016, 2.5 years before. And there is not any
Argument sounds good, except that there were actual findings in these documents from the time period and management that was there while Maya was there. That's the problem. And that's what the plaintiffs keep arguing. And the judge is like, I hear what you're saying, except hearing and seeing documents that say otherwise.
anything 2016. The proof that we put forward in Angela Green's death, the IJ related to the self-report of the Heart Institute and the Heart Institute alone. If you look at the report,
The self-report of the Heart Institute and the Heart Institute alone. Because the Heart Institute alone does not affect Maya. But is that actually true that it was the Heart Institute alone? The judge has a couple follow-up questions here.
if you read the report itself, you see talk of governance, you see talk of infection control, you see talk about contractual duties. But when you look at when the interviews were in each item of that report, it talks about interviews that were conducted in January of 2019 and the findings that were made in looking at documents over at that period of time or over the preceding 4 to 6 months. It says nothing about looking back 3 years or 2.5 years to this period of time because it simply didn't.
Did Ms. Crane lose her job because of this issue?
Ms. Crane lost her job because of the Heart Institute issue and the failure to report deaths and the failure of oversight regarding those issues. If you look at this, Judge, I apologize, Judge, but I don't mean to cut you off, and I want your questions. I really do. The point of this is, however, that it is oral.
Report out there already. Is that correct?
Here we
The
go.
other two
The
reports,
self-report occurred because there was a media report out there already. Is that correct?
Ding, ding, ding. The self-report, where you tell on yourself, happened after somebody caught you in the act and reported about it in the media, right? That's the question.
that is true, but there had been reports and there had been discussions beforehand.
Well,
There-
wait,
if you,
wait a second. Did the hospital report to whether it's the Joint Commission or any governmental agency prior to the media outing the hospital on the issue?
there was a report and a review that took place in the spring of 2018.
A report, a report. Who's reporting what to whom?
There was a media report then regarding
Media.
a heart case that was reported by the hospital to the Joint Commission. I believe, I don't have it right in front of me, I believe there was also a report to ACA and or CMS. There was a site survey that took place at that time. There was a review done and there was a follow-up and the deficiencies were cleared. There was, in addition to that, the entire triennial survey, which took place in August of
I'm
2018.
going to jump ahead a little.
The certificates.
I don't care what happened since Wednesday. At the time he testified to this jury. Answer: yes, they did.
Oh, here we go.
To you.
Have more problems we could possibly imagine.
So when witness Mr. Anderson
So here's when the judge gets a little angry. Some fireworks here. And he talks about exactly what was elicited from Mr. Anderson. And this is where the door ends up getting open. And the judge eventually says, we're talking about this evidence and this is why. And you'll hear this exchange here between the judge and Mr. Hunter.
is asked the following question. Let me talk to you about your overall view based on what you've reviewed. Did it appear to you, based on the materials you reviewed, the records, the policies, that all Children's Hospital had an appropriate safety plan in place for patient care? Answer: yes, they did. So,
Your Honor?
so I mean, that is something that the hospital adduced in front of this jury.
Yes, sir. And at the
And
time,
now you're telling me the door was not open.
Did they have the proper safety plans and procedure in place? And yet the IJ and the CMS and these investigations and these documents clearly state that was specifically one of their problems with the upper level management that was there while Maya was there. And it did actually affect the time period.
I mean, that's what you're telling me?
what I'm telling you, Judge, is two things. Number one, if he were to be called back, we can get him back. If he were to be called back, the proof would be that at the time that he referenced that statement, As of the fall of 2016 and 2017, the Joint Commission on the Accreditation of Hospitals had reviewed the safety plan in effect in 2015 and issued an accreditation based on that. And there's
Let me ask
certificate
you
of proof. And then,
let me catch up. Did you even provide witness Mr. Anderson with any of this information that we've been discussing since Wednesday afternoon? Was he provided any of it?
yes, sir. We sent,
He was provided the information?
I,
Because we had an issue
No,
with
no, no.
what was produced to Mr. Anderson, witness Mr.
And
Anderson.
remember, this was the witness who like got the 3-page outline, didn't have a chance to read the thousands of pages he was provided, but he just read the outline and the summary the defense gave him. The judge is like, wait, now you're saying he did have all those documents that he didn't review?
So I want you to be very clear as to what was specifically produced to witness Mr. Anderson. Very, very specifically.
since Wednesday, he was sent the certificates.
I don't care what happened since Wednesday. At the time he testified to this jury, had the defense even provided any of the information that we've been discussing since Wednesday?
May I ask Mr. Shapiro to address that, Your Honor?
Mr. Shapiro, do you want to step into the breach here?
Well, only to the extent that he was provided hospital policies and procedures yesterday.
That doesn't answer my question.
I did not provide him joint commission surveys, no.
It's like, did this witness have the information when he came and testified? Well, Judge, since Wednesday, we have provided. I don't care about what happened since Wednesday. Did he have all of the documents we're talking about today when he came and testified? Okay, Judge, can I bring in co-counsel? Co-counsel. Well, Judge, he had the policies and procedures. Stop. Did he have all of the documents we're talking about today when he came to testify? No, is the answer. But you see what questioning lawyers is like. It's like the answer is no. He didn't have these documents before he testified. We all already knew that. The judge knew that. He's asking a question that he knows the answer to, but it's very hard to get to the answer sometimes.
So I don't know if he looked at anything online, but to my knowledge, no. My understanding.
I don't know if he looked at any of it online, but we didn't provide it to him.
Well, just to explain. My understanding of his testimony, Your Honor, is that the fact that the hospital was able to operate at the time meant that they had gone through joint accreditation surveys. That was the simple basis of the statement that he volunteered.
Didn't even provide the information. Okay, what's next, Mr. Hunter?
Didn't even provide the information. Okay, what's next, Mr. Hunter? The judge is not leaving anything up to chance or up to, he's not making it unclear as to how he's feeling about the situation. He is not happy about how any of this has gone. The testimony was elicited by the defense attorney, not the plaintiff. It wasn't inadvertent. And they did it knowing it might not be true and without even providing all of the documents to that expert so he could come up with his own explanation. But instead, he was basically regurgitating the defense attorney's explanation, which the judge is taking issue with, as are plaintiff's attorneys.
I just point out to the court that we have been scrambling very hard to try to provide as much information as quickly as we can. And I believe that this issue can be addressed either with an instruction, a curative instruction, or some summary disposition. I think if we go full scale into it, we're opening a whole nother trial.
So what he's saying is he just wants the court to instruct the jury, either disregard Anderson's testimony, it wasn't true, whatever, or some kind of summary that actually there was something that happened, that maybe their policies and procedures weren't great, but we should not put all these documents in. We should not allow further expert testimony by Cochran or whatever the guy's name is for the plaintiff, their hospital expert. None of that should be allowed, because then we're going to have a whole other trial. It's going to be a big mess, appellate issues, all sorts of things. Whitney comes up, the plaintiff's a lawyer, and says that there were very specific violations that are spot on and that were there or provided 1 month after Maya left. And then he makes the argument about surveys looking back instead of forward, and the plaintiff wants sanctions. And I know for a fact Judge Carroll has ordered sanctions before against defense attorneys that violate the rules. So let's then hear what Judge Carroll says.
It's a bigger issue than what we have time to address today. And there's
He said it's a bigger issue than we might have time to address today.
bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now, what we should do and what we should not do. I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine about at the hospital at the time by Ms. Kowalski's
knowingly and intentionally presented to this jury that everything was fine at the hospital at the time of Ms. Kowalski's stay?
Admission. There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department. Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more persuasive or pervasive than just isolated to the Heart Institute. There's a view of this evidence that it is systemic, and systemic means systemic. And when we
And because of that, because the court does not seem like he thinks the only view of the evidence is limited to the Heart Institute, that means there is evidence that the jury can consider and potentially find that, based on these reports, based on this expert testimony, that there were systemic cultural problems in risk management and management generally and reporting problems that affected Maya. And that's the big ticket. If it was just the Heart Institute, it would be out, but the court is finding right here that there's a way to look at this, that it could have actually permeated throughout the entire hospital and affected Maya.
talk about culture, and I hear what the defense, they want it to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a light switch or buttons on this wall that I can't figure out how to turn on and turn off lights. But it goes to the essence of what an organization is, and that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggest, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. This culture might even go all the way back to the time of Johns Hopkins' purchase and acquiring of the hospital, which was, I think, 2011 or 2012.
He's not making a finding that it was there. He's just saying that there's evidence that if the jury looked at it, it would be reasonable for them to find that it was. That's very important. He's not making a judicial finding that these problems did affect Maya and were there and were pervasive and cultural and systemic.
So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented to this jury. Now, that being said, this is not a deep dive into what happened in the Heart Institute, what happened everywhere, but it goes more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins All Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut what the defendants presented. And then we'll let the jury make the decision as to whether it's relevant or not relevant. I don't think we need to get into a situation where we have, 14 days of testimony as to what happened.
So to skip ahead, he basically gives them the option. The plaintiffs want to strike the defense's testimony altogether and provide rebuttal evidence. The judge correctly says, if I strike his testimony, there's no need for rebuttal because now his testimony is out of the record and out of the minds of the jury, but you can't really unring the bell. So the plaintiff says if they have to choose, they'd want to put on the testimony, want to put the evidence back for the jury to determine. The defense obviously doesn't want that. They'd rather have just to strike the testimony and an instruction from the judge. That's what they would prefer, obviously, because it's less damning and less opening of Pandora's box. The judge ends up allowing the documents to come in, allowing the testimony to come in. So they get to call their expert. They get to bring the documents forward after a couple hours of them figuring out exactly how they want to bring the documents out. But eventually we do. And the expert comes back and there's some discussion about who the CEO was at the time of the IJ, which was the same CEO that was there when Maya was there. And then he gets into the definition of IJ, what it means, how bad it is. And we're going to listen to some of that.
They lose access to all funding quickly in a timely manner. Conditions.
In the second paragraph in the letter, it references a determination of immediate jeopardy. Do you see that?
I do.
Would you please explain to the jury what immediate jeopardy is?
So when deficiencies or non-compliance with the conditions of participation, the rule book, when those deficiencies are considered egregious, widespread. Actually, it's defined further down as, could you scrap that, please? It's defined as an immediate or serious threat to patient health and safety. So an immediate jeopardy is,
I mean, that to me, I can understand where Judge Carroll's coming from. That shows that that could absolutely affect Maya.
as severe a finding, and it carries an equally severe threat if an immediate jeopardy is not remedied quickly in a timely manner. You're 10 minutes, you're given, with an immediate jeopardy, you are typically.
But also, if I'm the defense, I can argue that January of 2019 is a long time after Maya was there. So they have to figure out, does this culture and systems and just permeate through long enough to where it must have been there in 2016 if we're talking about this finding actually occurring in 2019.
And required to provide an immediate mitigation plan before the survey team leaves. You then have to send a corrective action plan within 10 days and have that largely executed within 23 days. If you fail to meet that 23 days, you potentially lose access to all funding from Medicare and Medicaid.
Is it more or less a death threat to a hospital?
It is a financial death threat to a hospital. Yes, sir.
I'm sorry, what's the legal big leading on? Or
Is there any classification under CMS evaluation and survey more severe than immediate jeopardy?
None that doesn't involve literally taking over the hospital.
All right. If you could drop that and then pull up the bold text there, the 42 CFR sections for me. Now, a few moments ago, you referenced conditions of participation.
Yes, sir.
And we see here reference to the federal code of regulations. Are these the conditions of participation you were referencing?
Those are 4 of them.
All right. And why are these 4 on this document?
Okay, so the immediate jeopardy was centered on 4 specific shortfalls in their exercise of meeting.
So here are the 4 major problems they found at Johns Hopkins All Children's Hospital that made them classify the immediate jeopardy situation, which is basically a death threat to a hospital, like he said, financially speaking. Well, what caused that? These 4 areas.
The conditions of participation. Governing body is the interaction of, the board, which has ultimate responsibility for the entire facility, and the 2 primary parties, the medical staff, represented by the medical executive committee, and the administration or management of the hospital, which starts with the CEO. QAPI, quality assurance and performance improvement. That is making sure that we're staying between the guardrails and delivering good care.
I'm going to stop you there.
Thank you.
All right. So if you look at these 4,
All those 4, just look at them again. The governing bodies, the quality assurance, performance improvement, the medical staff, and the infection control. And basically he goes on to testify that they failed to make sure the care is safe and the outcomes are quality. They failed to put appropriate guardrails in place to make sure things were safe and being reported appropriately, and disclosure and communications with families. They did that poorly as well. And they went through the actual documents and they looked through what documents said, and they went through specific problems in the documents. I was going to see if we could throw a couple up here. They highlighted, some of them are hard to see. There was one that specifically said risk management department was not included on the organization chart, included the quality and safety plan, which we heard some testimony to that. No evidence of risk management reports or data collection in the past 15 months, and no historical data related to objective indicators of quality of care that have been tracked, trended, and analyzed. So they just didn't really care about patient care and the quality of patient care. See if we can. The culture was fear of retribution with speaking up. So if you did see a problem and you spoke out about it, you were afraid that they were going to retaliate against you. Over-reliance on department level case review. Issues did not flow freely to the board. Another problem, and a lot of this is going to have to do with punitive damages of what this hospital did and how they did it poorly. So these are the findings, the problems that they had, and then the findings that they found to be a problem, and then the corrective action plan, what they were going to do to fix it. Another focus area was disclosure and communication with families. The findings were it was inconsistent practices and documentation after adverse events, including disclosing our errors. Like, what else do you need? Closing arguments are going to be tomorrow morning. These slides would absolutely be used in my closing argument if I was plaintiff's counsel. Every time I talked about a problem, Miss Beatty did this, but guess what? Nobody wanted to say anything about it because if you did, boom, retribution. They didn't ask Maya Kowalski's family about this. They didn't ask him about that. They didn't run this by him because guess what? There was inconsistent practices and documentation after adverse effects, including disclosing our efforts when it came to disclosure and communication with families. They wouldn't tell them when something went wrong. They wouldn't tell them if somebody touched Maya or took a picture of Maya or did this to Maya or made her go to the bathroom on herself or set the bathroom far enough away or videotaped her or whatever they did to her. They didn't communicate with the family about it. They didn't clear it with anybody. They just did it because that's what they did at Johns Hopkins. That was the culture. These are the findings when governing bodies came in and investigating them. This is what they found. This is really, really, really damning stuff when it comes to the plan, the problems, the culture, the systems that were in place while Maya was there. Now I want to get to Cross. Howard Hunter crosses him. He does a good job of focusing on how the time period might not really affect Maya, but he steps in it a little bit when starting to argue with the doctor about stuff. The doctor definitely, I don't know if he's a doctor, sorry. I thought he was, but the hospital guy, the hospital expert that's on the stand, arguing with him about his expertise sometimes can be dangerous. And we're going to listen to a little bit of it to illustrate what I'm talking about.
So on the survey done March 7th,
So he basically wanted him to look and say, hey, they passed here, right? They passed with this visit. They passed with this survey. No issues here. And the hospital expert wouldn't answer these questions without actually looking at the documents, which is very smart. And as a witness, you got to force a lawyer to give you the documents. And he did. And here's what he answers.
So on the survey done March 7th, which was unannounced by the Joint Commission, they found elements of performance where there was insufficient compliance. Social work consult for a patient on suicidal precautions was not performed until approximately 9 hours after. There was another element of insufficient compliance that related to utilization of moderate or deep sedation or anesthesia.
And were there, were there indications of a follow-up that established compliance?
I'm looking for that.
He's like, okay, but eventually they complied, right? And the answer was yes. Eventually they were compliant in August of 2018, which again, we keep going back and back and back. And so if eventually they were compliant in August of 2018, they obviously weren't compliant prior to August of 2018, right? I believe those were the dates. But point is, the door is wide open that these problems and this culture was in place while Maya was there. And therefore, the plaintiffs are allowed to argue it. The hospital had to request 2 extensions to get their corrective action plan in place. They had to get specialists in there. And this guy kept saying, the new plan or the new team in place was great. And the new plan in place was great. But that's not the team while Maya was there. I think he said at one point, they weren't there in time to help Maya. Let me see if I can find that. It's right near the end of.
It does. And as I said, the new team actually worked really hard. It was too late to help Maya, but this was good work.
It was, they had already, the new team was already in place.
New team worked really hard, but it wasn't in time to help Maya. And then on redirect, most of it was objected to and kept out. Part of it was also that they were trying to make it seem like he didn't look through a lot of documents on cross. And he was like, you guys gave me thousands of documents. I looked through a lot of them. I'm not sure if I saw it. If you showed it to me now, I'd be able to tell you if I saw it. It was parents' weekend in Gainesville. I went to visit my son, went to the football game. It's really too bad his son went to Florida, and it's really too bad they lost this weekend. I really feel for them and Judge Carroll. Not really. You can't catch the sarcasm in my voice, but so they tried to make him look bad, and he just came off really personable, in my opinion. And the jury probably liked him, even though there's at least one null on the jury. But there was an interesting thing he stepped into that, again, they objected to, and it ended up getting sustained, but the jury heard it, and it's tough to unring that bell. So I'm going to move forward and you guys listen to it and see if you catch it, but it's like a zinger.
you try to keep them at bay.
The system, as it is reliant on self-reporting, is it not?
It's encouraged for sure.
It's reliant on the hospital that's being evaluated being an honest actor.
Correct. And there are some specific fallouts that require timely notice. For instance, an adverse event requires a code 15 filing if it's severe enough. And so that needs to be, Tallahassee needs to be notified ASAP.
And when they do self-reporting, it's not like, wow, how amazing they self-report. It's like, no, you have to self-report. It is required that you self-report under certain circumstances. And the fact that they didn't is horrible. And again, we know that the media reporting caused them to self-report. Let's keep listening.
In this instance, was it discovered that Johns Hopkins Children's Hospital was not self-reporting adverse events in a timely fashion?
I'm going to sustain that one.
Understood. This was all the genesis of an eventual self-report by Johns Hopkins Children's Hospital, right?
Overruled.
The survey that ultimately led to the IJ, which was backdated to 4 or 5 months earlier, did involve self-reporting.
What drove that self-reporting?
Overruled.
There were several issues at the hospital that were well documented by local press that actually ended up being a finalist for the Pulitzer Prize for investigative journalism.
Move to strike not responsive.
The jury's going to disregard the comment about the Pulitzer Prize.
It's like this story was broken by local media about how bad it was over at Johns Hopkins All Children's Hospital. And it was such a great story that they were considered for a Pulitzer Prize. That's not great. If you're Johns Hopkins, that's not great. And they objected to it. And the judge sustained only the part about the Pulitzer Prize, not that it was broken by the media first and Johns Hopkins didn't actually self-report. And I actually think the Pulitzer Prize stuff was probably a bridge too far. And I think it was the correct and proper thing to sustain that objection and strike that. But one of the problems in these documents and one of the problems at Johns Hopkins is their self-reporting, is their telling on themselves and making sure that things are done right. And if there was a problem, not trying to cover it up or whatever, as we saw in the documents that were presented. The retribution and retaliation if you called them out and that they weren't reporting their errors. We saw that in black and white. And this, quote unquote, self-report was just another one of those that they only actually reported when somebody in local news broke the story. How do you guys think a jury is going to respond to this? This is the last evidence the jury is going to hear before closing arguments, and on a Monday. And this is all they heard today was this hour and a half of this guy and these documents after a weekend. This is going to stick in their heads, if you ask me. Then he tried to ask, did you hear at this trial a high-ranking official at Johns Hopkins ever come in and say everything was under control? Objection sustained, wasn't allowed to get into that. And then the juror questions, the judge didn't ask any, and then the follow-up questions ended up getting objected to and sustained as well after sidebar. So this was it. This is what the jury heard. And to me, this was a huge fight by Johns Hopkins to try to keep these documents out, because now the plaintiff can argue that it's not just them saying there was problems at Johns Hopkins. It's other governing bodies, other reports, other surveys, media, Pulitzer Prize winning journalists or considered for that prize, all saw the problems at Johns Hopkins that Maya was a victim of. Now, this does open up some appellate issues. If the appellate judges find that this was so damning in 4043, or 403, it never should have come in. It's too prejudicial. Probative value was not enough. Or did they in fact open the door with this expert witness that they called to say everything was fine there? Really interesting stuff, ending with a bang in this trial right before closing arguments. And like I said, I think this is probably going to be a main component of the plaintiff's closing. I really want to know what you think. Does this change your mind about the case? Does this reinforce where you already were? Let me know in the comments and hit that like button before you sign off here. That's all we got for this one. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.